Today I would like to discuss about a new ruling on the case of cheating. That is, in the case of Philip Gain versus the state, reported in 6 CLR High Court Division, page 281. In this ruling, the Honorable High Court Division decides that at the time of framing charge, the magistrate shall not frame the charge mechanically, and in reference with the section 241A and 242 of the Code of Criminal Procedure 1898, the Honorable High Court Division said that at the time of framing charge, the magistrate should discuss the documents on the record, and considering the record of the case and such examination to the accused, and giving an opportunity of being heard to both the parties. If the magistrate forms an opinion that there are grounds to proceed against with the accused, only then the magistrate shall frame the charge against the accused. In this regard, the Honorable High Court Division opines that the magistrate shall not frame charge on a silly grounds. In this case, that is the Philip Gain and another versus the state, the magistrate framed charge against the accused under section 420 and 406 only by saying that there are sufficient elements of framing charge, and only on this the magistrate has framed charge. The High Court Division said here that this is not sufficient. If the magistrate wants to frame charge against the accused, he is to form an opinion, and that opinion must be reasoned. That is, the magistrate is to say in his order of framing charge what are the elements exist against the accused, and what are the elements or ingredients the offense which has been brought against the accused. It is to be substantiated, and only then, if the magistrate concludes that there are elements of framing charge, the magistrate should frame the charge. Otherwise, the accused should be discharged. So in this case, whenever a Philip Gain, a driver, lost a case under section 420, 190 and 109 of the Penal Code against the accused, stating that he was a driver of a non-government organization named as SHADE. He was a driver, but while he was driving his car, one of the director of the NGO wanted to drive in place of him. The driver, Philip Gain, resisted. Sir, you cannot drive in the highway. But yet that one of the directors of the NGO insisted to drive the car. At that time, he leave him place to drive, but ultimately one of the drivers who was driving the car met an accident in which his mother died, and his sister, and along with other passengers of the cars, plus the driver, got injured. At that time, the driver Philip Gain wanted to bring a case against the directors of the NGO, but they promised him 5 lakhs taka compensation and full paid leave and other facilities. But ultimately the directors of the company did not pay all those promised compensation facilities and full paid leave. On this incident, the Philip Gain, the driver, finally went to the Mohammadpur Thane's police station to file a case, but refused, and thereafter he lodged a complaint with the Court of Magistrates, and the magistrate, after examining him under section 200, sent the complaint on inquiry, but the inquiry report finds that the allegation is not true. In such a way, there are 4 inquiry reports. All the inquiry reports says that the complaint of the Philip Gain, that is the complainant, was false, not true. But yet that the magistrate framed charge under section 420 and 406 of the Penal Code. Against this order, the directors of the non-government organization directly files a miscellaneous case under section 561A of the Code of CRPC, of the Code of Criminal Procedure 1898, and finally got this rule. In this rule, the High Court Division said that the magistrate, without taking into consideration all 4 inquiry reports conducted by the high officials of the police department, and framed the charge whimsically. And that is why the High Court Division said that the magistrate should have taken into consideration the provision of section 241A and 242 of the Code of Criminal Procedure. If we analyze the section 241A, it is said that before framing a charge, the magistrate should consider the records and documents on the records, and examining the accused and giving an opportunity of both the parties being heard. And thereafter, if the magistrate is of opinion that there are elements to frame charge, only then he may frame charge. But in this case, the High Court Division said that the learned magistrate did not consider or take into consideration the provision of section 241A and 242 of the Code of Criminal Procedure, and that is why questioned the proceedings. So I may suggest the learned lawyers to use this ruling whenever you file an revision to the session judge, or whenever you file a miscellaneous case, that is quashment proceedings, to the High Court Division. In that case, you may refer the ruling before the court, saying that whether the magistrate at the time of framing charge formed a judicial opinion as to the grounds of offences, or as to the ingredients of it, whether those ingredients lie against the accused person or not. So you can refer this decision reported in 6 BLC, page 281, Philip Gain and another versus estate, at the time of hearing revision or quashment proceedings. Thank you for watching this video. If you want to join bar professional training course, we conducted bar professional training course for 17 years, and if you want to within a short time to be a efficient lawyer, you can join with us. Thank you for watching this video. You can communicate with us with the WhatsApp number given in the description box. Thank you.